We are recording.
Good morning, everyone. Welcome to the appellate court. I'm Judge Bright. I'm sitting this morning with Judge Prescott and Judge Levine on the matter of Herron versus Daniels, AC docket numbers 43560. We are conducting this argument over the Teams platform, so everyone is appearing by video conference. The matter is also being streamed live over the branch's YouTube channel. I'm going to start by asking everyone to introduce themselves just to make sure we can all hear and see each other. I'll start with the judges, then counsel for the appellant, then counsel for the appellee. And I'm Judge Bright.
I'm Judge Prescott.
Judge Levine, you're muted.
Apologies, I'm Judge Levine.
Good morning, Your Honor. Alan Spirer for the defendant, appellant Linda Daniels.
And good morning, Anthony Musto for the plaintiff appellee cross appellant, Mark Herron.
All right, I can hear and see everyone okay. I assume that's true for everyone else. If at any time you're unable to hear anyone, please let us know. If you're unable to see anyone, please let us know. If you get disconnected from the argument for whatever reason, please click back on the link and log back on. We will suspend the argument until we make sure that we have everybody present. I'm going to ask everyone to keep their microphones muted when they're not speaking to avoid any background noises and crosstalk. We would ask, though, that you keep your cameras on at all times so that we can make sure everybody is appropriately engaged and in the argument and still present. I would remind everyone that although we are all at different locations, this is still a court proceeding, and the hearing should be conducted as if we were all standing in the courtroom at 75 Elm Street in Hartford. The judges are going to we'll raise our hands if we have any questions. We'd ask counsel to recognize us. Again, we're trying to avoid talking over each other and background noises. If you don't recognize us, then we'll just jump in like we would if we were standing in the courtroom. Each side will have 20 minutes to argue. Because there's a cross appeal here, both sides can reserve some time for rebuttal. Just let me know how much time you want to reserve when you begin your principal arguments. I'm going to keep the time, and because we do not have our light system for these remote hearings, I will hold up a sign at 2 minutes, at 1 minute, and when your time is up. So with that, I think we're ready to proceed. Attorney Spire, are you ready to go?
Thank you, Your Honor. I'd like to reserve 5 minutes for rebuttal, please.
Okay, you may proceed.
Again, may it please the court, Alan Spirer. I represent the defendant appellant Linda Daniels in this appeal. I filed with the appellate court a notice of supplemental authorities last week, and the notice represents the court's decision in Carroll versus Yankwit 203 Con App 449. It's a case that was handed down last week, and that decision, I believe, informs a number of the issues that are before the court today. This is an appeal relating to a dispute over a security deposit. The plaintiff tenant had a lease for 1 year, and at the end of the lease, the defendant made certain repairs and attended to certain items of concern relating to the lease premises. Everything that the landlord did was done to repair the premises. At trial, the landlord presented paid bills for the work done, testified that the work was necessary to restore the premises to the condition that existed at the commencement of the lease, testified that she paid all of these invoices and that the charges were fair and reasonable. So this is a dispute about work actually done, not work that the landlord may have speculated needed to be done or thought were some kind of a consequential damage, but repairs that were necessary and that were made to restore the premises to the condition that existed at the commencement of the lease. The plaintiff objected to the repairs. Oh, and most importantly, the defendant landlord provided the plaintiff with a statement pursuant to section 4721D within 30 days of the termination of the tenant's tenancy. So that statute was complied with, in our opinion, and it was complied with in accordance with the standards set in Padrini v. Kiltonic and in the case I just cited, Carroll v. Yankwitz. In any event, the plaintiff objected to certain of the repairs and a trial ensued. And at the trial, the court found that certain of the deductions, probably about 60% of the deductions made by the defendant from the security deposit were legitimate. Money's due and owing to her, past rent that wasn't paid and items of that sort and some of the repairs. And found that $5,300, about 40% of the items that the plaintiff claiming, but the defendant was claiming, were not properly made pursuant to the terms of the lease, and in essence constituted reasonable wear and tear, items that a landlord needed to address without charging the tenant for them. On the first count of the plaintiff's complaint, breach of contract, the court awarded or said an appropriate award would be $5,300. And if this matter had ended there, and a $5,300 judgment was entered against the defendant, we wouldn't be here. But what the trial court then did was go on to find that by virtue of these repairs that the trial court felt were not appropriate, that deduction from the security deposit implicated the double damages provision of 4721D and doubled the entire security deposit, even though a portion of the security deposit was due and payable to the landlord pursuant to the court's decision that some $7,200 of the deductions were legitimate. The court then went on to find that by making these deductions pursuant to the landlord's charges for repairs, that was an unfair trade practice. This is a simple contract dispute. There was nothing in this entire scenario that entailed immoral, unscrupulous behavior. And what the court found in Carroll v. Yankwitz was that a violation of 4721D is not a per se violation of CUTPA. What the trial court appeared to hang its hat on, so to speak, was a finding that the disputed repairs were pretextual. A pretextual matter or pretextual finding requires a finding that what was done was spurious, or dubious, or fabricated. Nothing was spurious, dubious, or fabricated about the repairs that were entailed by reasonable wear and tear.
Counsel, when you say that there was nothing spurious or dubious about it, the trial court made a factual finding that they were spurious and dubious, for not that the repairs weren't done, but that there was no connection to the plaintiff's tenancy to the necessity of the repairs. And I think with respect to the carpeting, for example, the court specifically found that it was fabricated. Isn't that the trial court's job to listen to the witnesses, determine who's credible and who's not, and make those factual findings?
I think that a finding of pretextual is taking the issue way too far. In connection with the carpeting, for instance, the defendant testified that there was a stain. The painter pointed out to her. She investigated the stain, and the stain had not only ruined the carpet, but it soaked through to the pad, and the carpet was unsalvageable and needed to be replaced. Now, maybe she replaced too much of the carpet, since there was 2 areas to the staircase. And maybe that's just the risk you take when you allow a tenant to have a pet. But to say that that's pretextual, she didn't make it up.
What the court said that he didn't believe her about the stain.
Obviously, the stain, she said the carpet was 2 years old. There was a stain. Nobody said there wasn't a stain.
Yeah, but the judge didn't believe her. I mean, if the judge didn't believe her, what are we supposed to do with that?
There was no contradictory testimony. There was no testimony that there wasn't a stain. There was no testimony that there wasn't a dog. There was no testimony that it wasn't replaced. I mean, you know, I think that the court could say it's not the tenant's responsibility. I'm not going to charge the tenant for it. But to say it's pretextual and then trigger all of the consequences from that finding means that the trial court has unlimited discretion and an unlimited ability to characterize a dispute as being fabricated. Nobody fabricated the dispute. Nobody in their right mind replaces an entire staircase full of carpet that's 2 years old when there wasn't a stain. I mean, I think that the trial court has exceeded the bounds of being able to find pretextual. There's also a question as to whether even a pretextual finding is actionable. The court in Pedrini said, you know, if you comply with the requirement for a written itemization within 30 days, you've complied with the statute. And then in a footnote it says, well, we're not going to deal with pretextual here. But it didn't say that pretextual claims were accepted. So this court has a decision to make. And also set some standards for pretextual. This now just becomes an eye of the beholder type of thing, even when there's no contradictory testimony. I mean, it's allowing far too great a range of decision making to the trial court, even though it's within the trial court's decision making ability to find facts. The other issue is, let's say that $2,800 of the repairs were pretextual. We've doubled the entire security deposit. A $25,000 judgment was entered into this over this. There was, I mean, that's a draconian remedy for one item. That's pretextual. That means that, you know, a landlord can be 90% right, but if there's one item in that recitation that's perceived to be pretextual, then the entire security deposit gets doubled. I don't think that's what the legislature intended, and I think that's a draconian result. In this case, the damages that were claimed exceeded the amount of the security deposit by $1,800, and the landlord never made a claim. I mean, the landlord said, "Well, you know, I'm willing to let that go. We're not going to get into it over $1,800." But you know, the damages actually exceeded. And if you look at Carroll versus Yankley, there was a claim that because the tenant didn't address some kind of situation where water accumulated in a basement area, presumably unbeknownst to the tenant, and the landlord couldn't rent the house for a month, the landlord got to claim consequential damages. And in that case, the appellate court didn't say, well, that's pretextual, that's consequential damages. Those damages may have been caused by something else. That's a far more attenuated claim than what's going on in this case. In this case, the landlord actually replaced carpet, and the trial court said, well, you really, I don't believe you really had to do it. I just don't think you can define pretextual based on that set of facts. And I think it violates the plain error doctrine. And I think once we Once the trial court did that, then the trial court doubled the security deposit, found a CUPPA violation, awarded $12,000 in attorney's fees, awarded $19,000 in punitive damages. I mean, that's a steep price to pay. I mean, the trial court has turned a $5,300 dispute over what's reasonable wear and tear into a $60,000 judgment.
Do you agree that the trial court's CUPPA violation was based in large part on the mishandling, what the court deemed the mishandling of the security deposit?
The trial court certainly talked about it. The trial court seemed concerned about the mishandling of the security deposit. However, the trial court never really said that. I'm assuming that the CUPPA violation was informed by it. And I think we have to give the trial court the benefit of the doubt that somehow that played a factor in the trial court's thinking. But let's remember one thing that's really important about the security deposit. The plaintiff didn't prove that the plaintiff suffered any loss as a result of it. There was no evidence whatsoever that the plaintiff incurred an ascertainable loss. The plaintiff never met the standard for imposing CUPPA, and nor did the trial court. The trial court worried about how other tenants may be affected by the defendant's conduct and seemed to want to teach the defendant a lesson. But none of it was tied back to the plaintiff incurring an ascertainable loss, which is the threshold for finding a CUPPA violation. Thank you. I'll conclude my argument now rather than starting on something I'm not going to get done in a minute. And
all right, we'll add that 1 minute to your rebuttal time, so you'll have 6 minutes for rebuttal. Okay, Attorney Musto, how much time would you like to reserve for rebuttal on your cross appeal?
Let's do 2 minutes, Your Honor.
Okay, you may proceed.
Thank you, Your Honor, and may it please the court. My name is Anthony Musto, and I represent the plaintiff in this case, MARC HERRON. We are asking this court to affirm the judgment of the defendant's violations of the landlord-tenant laws and under CUPPA, and further to reverse the judgment regarding plaintiff's claim for money hadn't received based on the clear findings of the trial court and the public policy as stated by the legislature. The court stated in its opinion at page 11, this court finds that defendant has engaged in unethical, unscrupulous activity in violation of the stated public policy set forth by the Connecticut legislature and caused substantial injury to the plaintiff. Unethical and unscrupulous activity, violation of public policy, and substantial injury. Contrary to appellant's characterization, this case is not about a simple failure to return a security deposit or normal wear and tear or a simple breach of contract. This is about a landlord who the trial court found as a fact fabricated charges on a security deposit statement. About a landlord who used the security deposit for her own purposes, as the court said, her own personal piggy bank, but with the rubber stopper on the piggy side and underside removed. About a landlord who the trial court found never intended to return any of the security deposit. And in fact, even the amounts she admits are due in the reply brief filed with this court have not been returned to the plaintiff as of this day. A landlord who never placed any of the funds from any of her rental units, her 4 rental units, in an escrow account as required by law, even after she was admittedly aware of the legal requirement to do so. She violated the Connecticut Unfair Trade Practices Act as a result of her repeated, unethical, unscrupulous violations of landlord-tenant law. Taken together, the trial court found her actions so egregious that it awarded not only double damages, but also attorney's fees and punitive damages. The plaintiff asks that this court affirm those awards and reverse the trial court's denial of plaintiff's claim for money hadn't received. Regarding Carroll versus Yankowitz, I think that proves some of the issues that Judge Bright has raised. This court is able to look at the cases, the facts found by the trial court, and determine whether they rise to these levels, as they did in Carroll and as they did in, Carrillo. Those 2 decisions were very disparate, And the court made those determinations in those cases based on the facts found by the trial court. As far as this $1,800 additional, yes.
So did your client testify as to the absence of a urine stain or stain on the carpet?
I believe so, Your Honor.
You believe so?
I have seen nothing in the transcript, nothing raised by opposing counsel, certainly, that says that that he didn't, or that he did, one way or the other.
I'm asking you affirmatively. I assume you've reviewed the evidence presented at trial in preparation for this argument, and it would be helpful for me to know, because if he disbelieved her, that's not proof that there wasn't a stain there. It's just the disbelief of a witness isn't necessarily proof of a fact. It's just, I don't believe that testimony. So I need to know from you what evidence there was that there was an absence of a stain.
I do not recall the specific testimony regarding my client as to the stain. However, it is the defendant who's putting that issue into evidence. The defendant is claiming a $2,800 charge based upon this stain. The court found that that stain didn't happen. The court did not believe her evidence. She failed to meet her burden of that. And the court further found that it was so unbelievable, not just that issue, but there were 4 or 5 other issues regarding the plumbing, regarding the vacuum hose, regarding the tree trimming, regarding the cleaning, regarding the HVAC. The HVAC, in fact, the defendant, that is, presented evidence that predated the tenancy and in proof of her claim. All of those together, it wasn't just the pet stain, although that was the largest one, but all of those together, the court found, constituted a pretextual statement. And the plaintiff certainly testified as to those certain things. I cannot point you to the part in the transcript where the plaintiff did testify to that, because it hadn't come up. But it is the defendant's burden to prove that that pet stain occurred. And to the yes, Judge.
Why is it the defendant's burden to prove it? You're the plaintiff.
Correct.
You're saying that the money was improperly withheld and the withholding was pretextual. So why isn't it your burden to prove that there was no basis for her to withhold the money?
Because it is the, I mean, I believe the case law on this is relatively clear. Again, I don't know that it was raised by the plaintiff or the defendant in this case, but the defendant is the one who's making these claims, who's saying that based on whatever evidence she has, that these are appropriate deductions from the security deposit, that she's the one who presented it in her counterclaim, which, contrary to what Attorney Spryer said, she didn't just let this $1,800 go. She claimed it in her pretextual statement, and she further asked for $8,200 in her counterclame, which is a vast improvement.
No, my question is specifically as to the pretextual argument. Your argument is that these charges were pretextual and constituted a CUTPA violation. My question is, why isn't it your burden to prove not that she's wrong, but that they were in fact pretextual?
Well, I think we did prove that, Your Honor. It's certainly the burden to prove it's pretextual, but the charges themselves are claims that the defendant brought up. The defendant put those in issue. If the defendant had just kept the security deposit and not written down a false statement as to what the charges were, it might be a different story. But the defendant did that, and it's required by the statute, 21A-D2. 47A-21D2. It's required that the defendant do that, the landlord do that. And the landlord has to prove those damages. It is their burden to prove those damages. That was not an issue that was raised by the appellant, and so we didn't brief it. But it's clear that those damages are the appellants to prove, or the landlords to prove.
The appellant's not disputing the contract loss. The appellant, as I understand it, concedes that we didn't prove our case on the contract basis. What they're challenging is the CUTPA finding of pretextual and the statutory finding of pretextual. And you agree that you have the burden on that, right?
And we supplied that burden, Your Honor. Yes, we proved in court, and the judge found that she was simply not telling the truth about her damages. If she was not telling the truth about the damages, then she issued a false statement based on basically a lie, based on several lies regarding her damages. And that is a pretextual statement by definition. It's a pretextual statement under Carrillo, under any definition of pretextual. Judge Levine.
Yes, Attorney Musto, I would like to change the subject to the CUTPA Punitive Damages Award. It's found at A54 of Mr. Spire's brief, and maybe in other places, but the Punitive Damages Award under count 3, the CUTPA count, were determined. I'm just going to read one sentence from the opinion. The court will award punitive damages in the additional amount of $19,867.13, determined by the court as a result of considering the amount of the mishandled security deposit, $12,730, and pretextual expenses, $7,137.13. When I first read this, the use of those numbers struck me as rather arbitrary. What is the basis of determining punitive damages based on the amount of the security deposit and the so-called pretextual expenses? Where does that come from?
I think that the court, Your Honor, the judge has a wide discretion to award punitive damages. I cited the case of Ulbricht v. Groth, Connecticut Supreme Court case, where it talks about whether the defendant's conduct was reckless, whether it was intentional, whether the defendant's actions were taken in order to augment profit, as these clearly were, whether the wrongdoing was hard to detect. And in fact, in this case, the plaintiff was required to hire a lawyer and look into these, not only the bank records, but into the basis of the pretextual damages. Whether the injury was compensatory, where damages were small. In this case, their damages were actually large, considering the withholding of the entire deposit, and providing an incentive to bring the action, and whether the award will deter others, which we hope it will, from not only filing pretextual claims based on untrue claim damages, but also a mishandling of the security deposit. Recall that this statute, according to many of the lower court cases that have interpreted it, is designed to protect the tenants from just this kind of thing, from landlords using their deposits without their permission, from landlords putting that deposit at risk to the landlord's creditors. This is exactly what this statute's designed to protect. Judge Bright, I saw your hand.
Yeah, so what was the ascertainable loss that the plaintiff suffered due to the mishandling of the security deposit?
Well, stated in Costin v. Collins, which was actually cited by defendant, and I cited in my brief, the violation of 47A-21H, the security deposit statute, saying that there are only certain things you can do and not do. In doing so, that violates CUTPA. The court stated, defendants utilizing plaintiff's security deposit for his own purposes without the knowledge or acquiescence of the plaintiffs and without compensation for such use causes an ascertainable loss. But again, that's not the only basis for the CUTPA claim in this case. The pretextual damages, withholding the security deposit, in fact, claiming more damages, both in the accounting submitted to the defendant, to the plaintiff, and in the counterclaim of $8,200. Those are damages that those are ascertainable losses. We were forced to bring this case just to get the money back. There's also the issue of interest, which again is a minor point. But using someone else's money.
Well, my question is, Attorney Musto, let me give you a hypothetical case where the landlord has the security deposit, completely returns the security deposit at the end of the lease, but the tenant discovers that during the lease, the landlord was misusing the security deposit. Can the tenant assert a cutback claim there, even though they were fully paid back the security deposit and interest?
Under Costin v. Collins, yes, because the use of someone else's money without their permission, without compensating them for that, it results in an ascertainable loss, at least of the interest of that money. Now, an ascertainable loss doesn't necessarily need to be measured. It has to be, though, measurable. And if, for example, I got money from a bank, the bank would want interest. If I get money from anybody who's not maybe a family member, they're going to want some interest. They're going to want some compensation for that. Otherwise, they're not going to give me the money. In this case, what the landlord did, what the defendant did, was just take that money for her own purposes. She never even told the plaintiff she was doing it, let alone made any agreement to pay any interest or compensate them in any way. And under Costin v. Collins, that's exactly what happened there, and that's exactly what happened here. But again, in your hypothetical, that ignores all the other things that happened in this case. The pretextual damages, the fact that the court found that these damages didn't even exist, that she could not prove her burden, and not only couldn't she make her burden, the judge didn't find there was a disagreement or was a mere breach of contract case. The trial court found that she was actually not telling the truth, and that these damages were made up by her for the purpose of retaining the security deposit. That is certainly very serious, and that's exactly the kind of thing that Carrillo disallows. And all of its progeny, any of the cases you read, Shaw versus Worth is one that was cited by the trial court, in this case in its memorandum, from the same district, prior judge. All of the cases where the trial court finds that kind of pretext, finds that kind of dishonest testimony, the unscrupulous, unethical, immoral, mailing a false statement, claiming money through the U.S. Post. I mean, these are the things that give rise to cutback claims and punitive damages. The basis for those damages, again, is discretionary to the court. Now, the court may have just said, well, these are the amounts we're going to use to base it on. There's no reason that there's been no argument, frankly, from plaintiff or defendant, rather, that was an abuse of discretion in any way. We could have talked about that maybe, and the argument I would say is that the court can base punitive damages on reasonable numbers. I think if this number were vastly higher, we might have an abuse of discretion argument. But the fact that the judge just happened to use those numbers doesn't mean he was simply basing it on those numbers. I mean, he added them up clearly. But it's not an abuse of discretion to use, it hasn't been argued, it hasn't been briefed, there's been no statement at all that it's in some way an abuse of discretion to use those particular numbers. I would like to move on briefly to my money hadn't received argument. In this case, Your Honor, the clear violation of Section 47A-11A, because not only did the defendant herself use the word abandonment, that the plaintiff had abandoned the property, but the definition of abandonment in the very next statute, in Section A2 of that statute, is an express statement by the occupants that they do not intend to occupy the property. Either definition you use, by either definition, plaintiff abandoned the property in October, and even the trial court said the plaintiff did stop physically residing at the premises in October of 2016 on the first page of its memo. The defendant admits she took no actions to relet the property, and there was no pleading, no evidence of any actions that were in any way alleged to be reasonable. There's not even an argument made by the defendant at any time that she took reasonable actions. It's not in her pleading, and there wasn't any evidence of it. That means that the statute kicks in and the violation terminates the lease as of the date the plaintiff moved out. That's why we cited the Supreme Court cases regarding money hadn't received. The real ground of recovery is the equitable right of the plaintiff to the money. Stratford versus Winterbottom, the Supreme Court case cited in the brief. The legislature has made that equitable determination. As between a tenant who moves out and a landlord who refuses to take any action, as she did here, instead just demanding the rent, the legislature has determined who wins that battle of equities. In this case, she admits she did nothing, and let alone any reasonable activities. As happened here, thank you, Your Honor.
That's your time. So you'll have 2 minutes for your rebuttal.
Thank you, Your Honor.
All right. Attorney Squire, you have 6 minutes.
Thank you.
I would like to go back to Judge Prescott's question. I think it's very important because looking at the opinion at A47, the judge said the carpet replacement was wholly fabricated and basically made up. So, was there evidence in the trial coming from anybody that there was in fact a stain on the carpet, a urine stain on the carpet?
Yes.
And what evidence was there and from whom?
The defendant testified that she hired painters to paint the house, that the painters advised her. It's not a house that she was living in, but the painters advised her that there was a stain on the carpet, that the stain was malodorous, and that she needed to attend to it. She examined the carpet. She testified that she examined the carpet. There was a stain, that the stain had soaked through and had also destroyed the pad beneath the carpet. That she went back to she had previously bought carpet 2 years earlier, that when the lease began, there was no stain on the carpet. No one complained about a stain during the tenancy.
And the evidence was the tenant had a dog or a cat? Or
Yes, the tenant had a dog, and the tenant's response was not that there wasn't a stain. Never testified there wasn't a stain. Just said, my dog doesn't pee on the rug or doesn't pee in the house.
Now, I take it there are two separate areas of rug that we're talking about, and it appears that the stain was in one of them and that your client attempted to replace the entirety of the rug rather than one area. Is that correct?
Correct. There was a stairway with a landing, and I don't know exactly where the stain was. I've never seen it personally, but obviously the stain was in one place and not throughout the carpet. The landlord also testified that it wouldn't look right to just replace some of the carpet, and that she felt she needed to replace all of the carpet. And she actually replaced the carpet from the same vendor that had sold her the carpet 2 years earlier, entered the bill in evidence, and said that she had paid it and thought the charges were fair and reasonable. So
thank you.
It may be a lot of things, but it's not pretextual. She didn't make it up. And she's not projecting that, well, I may have to replace the carpet. She did it and paid for it. I'd like to talk about the security deposit. The only appellate court case that deals with this issue is Tarker versus Filpovic, Filpovic, which is cited in our brief. And in that case, the court held that the failure to place a security deposit, an escrow account, is not a CUTPA violation. It's certainly not a per se CUTPA violation. There was absolutely no evidence from the plaintiff that he suffered any sort of an ascertainable loss as a result of what the defendant did with the security deposit. At the termination of the lease, there was more than enough money in the account into which the security deposit had been deposited to refund it if necessary. And lower courts have had a number of decisions on the subject, most of which favor my client's position. One court said it's not a housing court matter. It's something that the statute relegates to the banking department. And if there's a problem, go to the banking department. Other courts have refused to adjudicate the issue. One court that opposing counsel cited said, yes, it's a potential violation. But that's a lower court decision, and there are other lower courts that it's not a CUTPA violation. Punitive damages counsel says we didn't claim of properly do. I think this is a case that cries out for review, and I believe that the trial court has erred in terms of
16, and this urine stain was discovered by the defendant in May or June of 2017 after she had been in the house multiple times. The cross-examination by me of the defendant indicated that she'd been in the house numerous times, other people had been in the house numerous times, and she never made any claim, she never gave any notice, she never said anything about this urine stain until she decided to replace the carpet. That is, so the initial denial by the defendant, by the plaintiff, as well as the simply unbelievable testimony of the defendant, led the court to believe that this was completely fabricated. That is a factual finding by the trial court, and I would suggest that there is no reason not to, there's no reason to overturn it. Attorney Spryer said that there was more than enough money at the end of the tenancy to pay back the security deposit, belatedly, I think, but that the defendant took money from somewhere else and put it into that account at the end of the tenancy. We'll bear out there was very little money in the account, in the security deposit account.
Courtroom very shortly. We will take the matter under advisement, and the court will stand in recess until 2 p.m. this afternoon. Have a good day.
Thank you, Your Honor.